Good morning, everyone, and welcome to Assembly Judiciary. Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch.
Here.
Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong. Assemblyman Urick. Chair Miller.
Here. And please mark Assemblywoman Bilbray Axelrod absent excused and Assemblywoman Summers Armstrong present when she arrives. And with that, just a few reminders for everyone this morning. Please make sure you turn off anything on any of your electrical devices that will make noise and be disruptive during the hearing. Also, a friendly reminder to make sure that you're getting your documents and anything for your presentation in by noon the day before your scheduled hearing, as well as, again, we've been asked to remind folks not to approach the dais. With that, I would like to welcome everyone here in Carson City, as well as those that I see in Las Vegas, and of course, anyone watching online or online through Nellis or our YouTube channel. With that, we have one bill that we will hear today, and we also have 3 bills on work session. So we're going to, I'm sorry, what? We're going to go ahead and start with the work session. So with that, I am going to ask our policy analyst, Ms. Diane Thornton, to go ahead and walk us through the first bill.
Thank you, Chair. Diane Thornton, Legislative Council Bureau for the record. Our first bill is Assembly Bill 32, which makes various changes relating to criminal justice, sponsored by this committee on behalf of the Department of Sentencing Policy and heard on February 15th. This bill revises the qualifications of the Executive Director of the Department of Sentencing Policy and the membership of the Sentencing Commission. The bill requires that the system of graduated sanctions used by parole and probation officers when responding to a technical violation of the conditions of probation must include guidance on the use of confinement in a jail or detention facility and electronic monitoring. Lastly, the bill revises provisions relating to the temporary and full revocation of probation and the suspension of sentence or parole supervision for technical violations of the conditions of probation or parole. There are 2 proposed amendments. The first amendment is proposed by Victoria Gonzalez, the Executive Director, Department of Sentencing Policy. According to Ms. Gonzalez, she worked with Chairman Dorico of the Parole Board, also the Division of Parole and Probation, the Public Defenders, Las Vegas Metro Police Department, and other law enforcement lobby, and John Jones and Jennifer Noble of the DAs. This amendment amends Section 4 and 7 of the bill to make the violation of certain supervision conditions for sex offenders a technical violation. It amends Section 5 to leave a 30-day temporary revocation for probationers. Amends Sections 5 and 8 to require the application of credit for time served when ordering a temporary revocation. Amends Section 5 and 8 to require a finding of the graduated sanction have been exhausted. Amends Section 3 to require the assessment to be evidence-based. Amends Section 5 and 8 to authorize the judge or parole board to revoke a probationer or parolee upon the request of the probationer or parolee. Delete subsection 3 and 5 of Section 6 of the bill. Adds a new section to provide that data collected, housed, and analyzed by the Department of Sentencing Policy is not a public record and is not subject to subpoena. It authorizes the Nevada Local Justice Reinvestment Coordinating Council to accept gifts and grants, and requires the Department of Sentencing Policy to further study temporary revocations and submit a report to the 2025 legislative session. There's a second amendment proposed by Katrina Goodsby Thedford, Executive Director of the Nevada Homeless Alliance. She proposed amending NRS 176.01343 to require that the department to include housing status as a data point to be collected at prison entry and exit. Thank you, Chair.
Thank you, Ms. Thornton. Members, are there any questions? Not seeing any questions, I will entertain a motion to amend and do pass AB 32. I have a motion by Vice Chair Marzola. Do I have a second? Second by Assemblywoman Considine. With that, is there any further discussion on the motion? Okay, not seeing any. All those in favor, please say aye. Aye. Anyone opposed? All right, the motion passes. Thank you so much, and I will assign that floor statement to Vice Chair Marzola. Ms. Thornton, please walk us through Assembly Bill 67.
Assembly Bill 67 creates the Fund for the Compensation of Victims of Securities Fraud, sponsored by this committee on behalf of the Secretary of State and heard in committee on February 21st. This bill creates the Fund for the Compensation of Victims of Securities Fraud and requires that the money in the fund be used for the compensation of certain victims to whom the restitution is owed. There is one amendment for this measure. Assemblywoman Cohen proposed adding language to the bill to allow the fund to accept gifts, grants, and donations. Thank you, Chair.
Thank you for that. Members, are there any questions? Not seeing any questions, I will entertain a motion to amend and do pass AB 67. I have a motion from Vice Chair Marzola. Do I have a second? Second. I have a second from Assemblywoman Newby. Members, are there any further discussion on the motion? Not seeing any, I will take a vote. All those in favor? Aye. Anyone opposed? And the motion passes. I will assign that floor statement to Assemblywoman Hanson. You're welcome. Ms. Thornton, Assembly Bill 255, please.
Assembly Bill 255 revises provisions governing adoption, sponsored by Assemblywoman Cohen and heard in this committee on March 13th. This bill authorizes an agency which provides child welfare services to provide financial assistance to a family that adopts a child with special needs until the child graduates high school or reaches 19 years of age, whichever comes first. There's one amendment proposed to this measure. Assemblywoman Cohen proposed adding Assembly members Bilbray Axelrod, Hanson, Orentlicker, and Smith Newby as co-sponsors to the bill. Thank you, Chair.
Thank you, Ms. Thornton. Members, are there any questions? Assemblywoman Cohen, was that a friendly amendment? Friendliest. With that, I will go ahead and entertain a motion to amend and do pass Assembly Bill 255. I have a motion by Vice Chair Marzola. Do I have a second? Second. I have a lot of seconds. I think I hear a second from Assemblywoman Hanson. And with that, I will go ahead and take a vote. All those in favor? Or I'm sorry, is there any discussion about the motion? All right, all those in favor, please say aye. Aye. Anyone opposed? And again, the motion passes, and I'll assign that floor statement to Assemblywoman Cohen.
Thank you.
You're welcome. That concludes our work session for today. We'll move into our bill hearing. Today we are hearing Assembly Bill 340. Assembly Bill 340 is sponsored by Assemblywoman Summers Armstrong and will be co-presented with Jonathan Norman from Legal Aid. This measure revises provisions governing certain actions and proceedings related to real property. Assemblywoman, do you have any co-presenter in Las Vegas or just the two of you?
Thank you, Madam Chair. Just the two of us.
Okay, so I will give you a few moments to get settled in. The hearing is officially opened, and so whenever you're ready, please proceed.
Thank you, Madam Chair and members of the Judiciary Committee. My name is Chandra Summers Armstrong, and I'm the representative for Nevada Assembly District 6 in the heart of Las Vegas, Nevada. I sit before you today to present Assembly Bill 340. And the purpose of this bill is very simple, and that is to bring the process of summary eviction in line with all other civil matters that are heard within the state of Nevada. We often hear the term summary eviction, and I think it's important that we break it down to its basic core. In terms of law, summary means short and concise, and eviction is the removal or expelling of someone, generally a tenant, from real property. So, summary eviction is the quick removal of a human being from a place where they live. This is not a civil trial where you and I have a disagreement about a contract. We are not arguing over whether or not you did services that I paid you for in a manner that I believe are appropriate. This is a process where we are telling someone that they have to move and move quickly. We're not making any significant changes except to require that in this case, the landlord file a complaint with the court that is answered by the tenant. Today with me is Jonathan Norman. He is with the Nevada Legal Services offices in Southern Nevada. They are on ground zero of what has turned into be a crisis of summary evictions and the lack of what we believe is due process for our citizens. I hope you will listen attentively. We look forward to your questions. I know there will be many, but we want you to hold this one thing in mind, and that this is to bring the process of summary eviction in line with all other civil matters that are heard in our courts. Thank you.
Chair, members of the committee, Jonathan Norman. I'm with the Nevada Coalition of Legal Service Providers, which includes the Legal Aid Center of Southern Nevada, Northern Nevada Legal Aid, the Senior Law Program in Clark County, and the Volunteer Attorneys of Rural Nevada. I want to thank the committee chair and Assemblywoman Summers Armstrong for their attention, and for the Assemblywoman for bringing this bill. I also want to thank the committee staff for helping troubleshoot some issues yesterday. They were really great to work with. So if it's okay with the chair, I'm just going to have a brief statement, go through a very short PowerPoint, I promise. I don't like PowerPoint, so it is brief, and then just walk you through the bill. So Nevada has a housing crisis, and one of the primary ways tenants and landlords interface with the judicial system is through the summary eviction process. In Southern Nevada, the Legal Aid Center operates the Civil Law Self-Help Center, which is a legal emergency room that serves over 300 people per day seeking assistance because they are being evicted. That number can reach over 500 people on some days. This situation is repeated around the state as tenants, feeling the pinch from inflation, are left making difficult choices between rent and groceries, rent and medicine. So there is a lot to talk about with housing, from costs to evictions to rental assistance to delays in process to affordable housing and, of course, fees. But this bill, despite all the blue, is really simple. This bill would require the first document filed with the court in a summary eviction action to be a complaint, followed by an answer from the tenant. Our current system requires the tenant to file an answer before a complaint has been filed. And once a complaint is filed, the tenant no longer has the opportunity to file an answer. That opportunity has passed. It is a confusing thing to even put into a sentence, right? That the complaint comes after the answer, and when the complaint is filed, the opportunity to answer has passed. It's even more confusing for tenants to understand. Many tenants are waiting for a court-stamped document, and the first time they really understand that they are being evicted is when they receive a lockout notice from the constable's office. At that point, it is too late. Many of those tenants come to legal aid offices around the country at that point, and their opportunity to be heard by the court has largely passed at that point. I do want to acknowledge that we are in ongoing discussions with industry that I think are fruitful. I think everyone benefits from having a clear and concise order for things to process through summary evictions. And what makes Nevada unique from other states have quick processes for eviction. What makes it unique is the filing of the answer as the first document filed in the court. So I just want to draw your attention to the two handouts, right? They look really similar because we're only making one small change. And the small change is in this box right here. And it says that the tenant has the ability, I should read it, huh? The tenant It goes through, the landlord files a complaint with the Justice Court after the 7-day notice period expires. So with that, I'm going to run through our quick PowerPoint, which just goes through the process as envisioned with AB 340. And for those of you who don't know, I'll just give like a little brief context. Right now, and I'm just going to talk about 7-day notices to pay or quit, because that's the simplest one for us to address. And it's 90% of the evictions in our state, over 90%. Landlord, you don't pay your rent, landlord posts on your door a notice that says you have 7 days to pay or quit. That means you can catch up your rent. If you catch it up, there's no reason for an eviction. You can vacate the premises, so you can surrender. If you surrender, there's no reason for an eviction. Or third, you can file an answer with the court. No complaint has been filed at that point. On the 8th judicial day, so once those 7 days have lapsed, if you're a tenant and you're still occupying the premises and you haven't paid, then the landlord goes to the court and files a complaint. At that point, the court tries to match that complaint and see if an answer has been filed. If they match them up and there was an answer, they set a court hearing. If they look and there was not an answer, then they issue a summary eviction order, which then gets transmitted to the constable. And the next thing the tenant sees is that 24-hour lockout notice. So that's posted, and it says, I'm the constable, you've been evicted, I will be back not sooner than 24 hours and not later than 36 hours from right now to change the locks. So that's what we're working under right now. So, and then I'm going to go through the proposed changes. Step one, the landlord, and I'm just going to talk about the 7-day notice to pay or quit because it's just simpler, but it is for all summary evictions. The landlord serves the eviction notice. So this is the same. Within that notice period, the tenant, again, vacate and pay or cure the lease violation, which wouldn't be in the 7-day notice, but they can fix the problem, right? And then the proposed change is at the end of the 7 days, the landlord files a complaint with the court requesting the eviction of the tenant. When that is served upon the tenant has 10 days to file an answer. Must be filed, with the appropriate justice court. And if they do not file within that 10 days, then a default eviction will issue. If they do file an answer, then a court hearing is going to be set, which is the same thing we have now. We're just switching the order. They must hold the hearing if the tenant files the answer, and then the judge decides based on the evidence they hear whether they should grant the eviction or it should be denied. If the eviction is granted, we're still back in the universe we're in right now. We have that order transmitted to the constable's office. Landlord goes and pays the fee at the constable's office. 24-hour lockout notice gets posted on the door. So that's going to be the same process. If the court determines that the tenant has a legal defense, the court doesn't grant the eviction, and instead the proceedings will have to be conducted pursuant to NRS 40.290 or 40.20. We're not changing anything there. That is how the current law sits. And then this is just, again, step by step, kind of breaks down those previous slides. And then if it's okay with the chair, I'll just walk through the bill so that everybody is on the same page. So Section 2 of the bill just sets out the new procedure for summary eviction. And it goes through the slides we just went through, so I'm not going to belabor those points, but we're changing the order, and that sets out how that process will flow. Section 3 spells out service as it relates to weeklies outlined in subsection 3 of Section 2. While we're working with stakeholders, one of the things that's become apparent is that that section is not used by our courts. We have no attorney at legal aid, legal service providers that's ever had a case using that provision. I spoke with a judge who's been working in this space for 15 years. She said that she doesn't know if she's seen one case under that provision. So I think as we're talking and we're thinking about making this a statute that can be approached by lay people, and that's tenants as well as landlords. Most landlords don't have an attorney when they go to court either. So we're discussing that, and I think it makes sense to probably remove that, but we weren't there with an amendment for this morning's hearing. Section 4 sets out the timeline for the constable to act when they receive the order of removal. Section 5 reorganizes NRS 40.253. Section 6 does the same. And I will say, there's a lot of blue in the bill, right? So that makes it seem like there's a lot of changes. There's not. Most of this is reorganization, and the change is the one, and I'm just going to keep saying it, switching the order. We've got a complaint filed, followed by an answer. Section 7 lays out the new process for other types of evictions currently that are in the current Chapter 40. Section 8 lays out the same procedure for commercial premises currently found in NRS 40.2542. Section 9 through 20 makes conforming changes, and Section 21 enacts the law. And with that, I think we are ready for questions. Thank you.
Madam Chair, before you begin, may I just interject that we have reached out to stakeholders from all sides. I would like you all to know that you have an amendment, proposed amendment on your desk, and that amendment came from robust discussions that happened on Monday evening with the directors of both the Nevada Rural Housing Association, who I believe is here, Mr. Brewster, and Brewer, I'm so sorry, and Louis Jordan of the Southern Nevada Regional Housing Authority. We found in Section 7, subsection 3.2, that there was some duplicative language, and that was removed, and that is what is before you. We were not able to find a place of agreement with those in the apartment association nor in the realtor space, but we believe that there is hope that we can find some common ground. But at the end of the day, I repeat, this is about bringing a process that is currently, see if I say this right, I hope Armstrong is listening, extrajudicial. It is outside the court, and placing it firmly within what we believe are the common practices of the court, which is that all of these kinds of disputes are settled by first having someone complain and then someone answer. So now we are ready for questions.
Thank you for that, Assemblywoman Summers Armstrong. And I will say that some of the people that you are working with have reached out to me and echoed the same sentiment, that they are continuing to work with you and are just appreciate that process and that willingness. And Mr. Norman, thank you for making what often can be a very complicated process for presenting it in a very concise manner, and we love the charts, so thank you for that. With that, our first question will be from Assemblywoman Mosca.
Thank you, Chair, and thank you for this. I appreciate that. Before we started, I got to see the process at the court, so thank you for that. My question is just looking at the chart, it seems like it would save time for the courts if we did this switch. Can you share more?
Jonathan Norman, for the record. So save time for I would want to defer to the courts to answer that question, but I think that what it does is it moves time to where it can be more meaningful for the tenant. And what I mean by that is right now when we have the process, there can be a lag between, where that complaint, well, one, the court has to do that matching, which is not, I don't believe in, if I misspeak for the court here, I don't believe that's done automatic. So they are hand matching those complaints, or looking through, not hand matching, but they're going through the, their database and have to match them. They're not automatically matched. But what I mean when I say that it creates an opportunity for more meaningful time is, one of the biggest costs to our counties is rapid rehousing and the social service element. And by moving time that, right now the landlord files that complaint, and then there's a lag while the court is matching that up. And that can be several days. So while this is, I don't want to hide the ball here, this would mean more time, but it's not going to be strictly 10 days, because I think there will be a time savings for the court in doing with the complaint filed first. So we're going to save some days there. So when we think of 10 days, it won't be 10 days from the outside perspective of the court. On the inside, I think it allows county social services to engage and start getting upstream. Now, you might say that's not a lot of days for county social services to get upstream, but I think it does give them an opportunity to intervene for tenants who aren't going to be able to maintain their housing or might be eligible or need rental assistance. So thank you for the question.
Thank you, Assemblywoman. Our next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman, and thank you for the presentation of this bill, especially your fantastic chart. I was wondering, how is this process done in other states? Is it the way that we currently have it, or the way this bill proposes to do it?
Thank you for the question. The short answer is the way we are proposing in 340. The longer answer is every state has a summary or a quick proceeding, right? What makes ours unique is it's the only proceeding I'm aware of where the answer is the first thing filed with the court, the first document that opens a case. And I'll just speak to, so we've done like a survey and looked at other jurisdictions. Can't find any that have that unique thing. I will say I practiced in New Mexico previously. New Mexico's summary process is very similar to what we're outlining in AB 340. The only difference is you can actually, in the 10 days, you can file your answer as a tenant, but you already get a court date before you file your answer. Or you can show up at the court date and assert any of your defenses verbally to the judge. And so, I would say that is probably, more tenant-friendly than what we're envisioning here. But I think this is a substantial change in our process that is good. I think ultimately will be good for all stakeholders. So thank you for the question. I should say that at the beginning. Thank you for the question.
Thank you for the question, and thank you for the response. Our next question is from Assemblyman Urick.
Thank you, Chair. And I apologize if you addressed this in your presentation. I was reading through the amendment, and by the way, I also greatly appreciate, as a visual person, your slides. They're very helpful. So if I missed this, I apologize. But can you clarify, I was concerned in Section 3 when it looked like that this might apply to the short-term rentals in this process, and the idea of them having to have notice in their lease or something that would require, before an eviction could be served, that would be applicable on like an Airbnb. Was that going to be removed, or is that still part of this? And can you clarify that?
Thank you for the question, Assemblyman Urick. Jonathan Norman for the record. So we're still in discussions on that. So I've gotten feedback from the courts and other stakeholders and our own attorneys practicing in this area around the state, and nobody has seen that section of our statute used, and we're talking people with 15 years practicing in this space. So, in the spirit of making this simple and something that can be approached by lay people so that we have landlords and tenants that can engage with this statute, go to court, and know the process, that they understand it and do not need an attorney necessarily to represent them. I think it makes a lot of sense to remove that section, and we're discussing that. We just weren't there today, and I can say that section, if you read through the whole bill, right, it echoes throughout. Like, it's constantly being referenced, and there's some times where a section that references it is then referenced. So I think it creates a lot of confusion, and I honestly don't know where that originated. I just know it's not used in practice. So thank you.
Thank you. Our next question is from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. So I want to talk about the landlords and what we often hear about, the mom and pop landlords, and how this is going to impact them. I know from my practice, I don't deal with this issue, except I dealt with it once for an odd situation where it was post-divorce and a wife ended up becoming a landlord and to her ex-husband, and then needed to evict him, and I had to help her with that. And as an attorney, I started with this and I went through the statutes, and I remember I kept saying, this can't be right. What do you mean an answer gets filed first? It just makes no sense, and had to call other attorneys I knew to, to make sure that I wasn't crazy, that I wasn't missing a big section of the statute and the process, and, went to the self-help center to try to figure it out through air forms, because they're usually a good way to figure things out. So can you just kind of address, you touched on it a bit, but how is this going to help our true mom and pop landlords?
Jonathan Norman, for the record. Thank you for the question. So I think I appreciate the shout out to the Self-Help Center. Their forums are amazing. I think attorneys around the state look to them. So second, when I took this position, I had come from CAP, right? So I was representing kids in foster care and doing work in education. I had done some landlord-tenant work in New Mexico. I worked at a legal aid there. And so I asked our lead consumer attorney, I said, can you walk me through eviction? I need to get up to speed here. So he walked me through it, and I was looking at him like, no, that is not the process. There is no way. And also it's an extremely cumbersome statute to engage. If you do not practice in this area and you read this statute one time, you are not going to get it right, whatever you're doing. So then the idea that, tenants who are almost all pro se and landlords, I think they're, representing themselves over 50% of the time in these actions. And so I think for those mom and pops, having a statute that is clear and readable is going to be really beneficial. So how filing the complaint specifically helps them, because there's like two things we're trying to do, right? Make it simpler, which I don't know, the bill as written, I think we have worked with stakeholders to make it simpler and clearer. Because if you read the bill, I was like referring I need 3 computer screens to refer back to sections of the NRS. And I think that just echoes how difficult this statute was to start with, right? I think LCB did a great job in giving us a framework to then talk with people practicing to make it simpler, right? I think filing the complaint first in a process, how that helps mom and pops. I don't know that it hurts mom and pops, and I think it helps the tenants know that this is an eviction. So what we often see is people come to the self-help center, they've received a notice. If you've moved here from another state, the idea that that notice is the first pleading, not court, it's not a pleading, it's not stamped by the court, I think is really confusing. And they're waiting for a document from the court. So then they come to our office. So I think in normalizing the process, it will help all stakeholders. But specifically how having the answer and complaint, I think that does help tenants and help our social services engage with tenants earlier, which that could benefit landlords if the social services is able to help navigate either a move out to different housing or is able to save that housing through rental assistance. Thank you.
Thank you. Our next question is from Assemblywoman Hardy.
Thank you, Chair. Thank you for this presentation. And when I worked in justice court, this was one thing that I did was process evictions. So luckily I have a little more insight into understanding of it, but your demonstration was exactly what happens and very helpful. So I had some questions on Section 211C, and this is in regards to where this section would not apply, and specifically in C, tenants who provide proof that they're a federal worker, tribal worker, state worker, household member of such a worker during a shutdown. So yes, we would hopefully never be in a situation of a shutdown again in our state. But if you could just talk about how you came about putting that specific group in there, C, and then is there an avenue for eviction for those, if there were a shutdown, what proof is required, and then, our shutdown lasted much longer than we thought. So would they continually do that, or just kind of explain that letter C? Thank you.
Yeah, thank you for the question, Jonathan Norman, for the record. So I would point out that while This language is in blue. It's not new language. It's in our current statute, and it's blue because it's reorganized. So all this bill does is the simple thing that makes the complaint filed first. I could find an answer for, if you wanted offline to talk about why this was in our current statute, I think I could get answers, but I don't have those today because it's not a change that this bill is addressing. It's just in blue because it's reorganized from one section of the NRS. And when I say one section of the NRS, one section of Chapter 40, the chapter we're in, to a different section. And I think that was done because we would like to have our statute more easy to read. And I don't want to say like we're there with how it sits today, so we're working on that. Appreciate it.
Our next question is from Assemblyman Gray.
Thank you, ma'am. Just looking at the requirements for posting in Section 4 and then removal, what happens if, the posting is on a Thursday or the order is received on a Thursday? I mean, you could put somebody in some real precarious positions over the weekend. So if the posting if the order is received on Thursday, the posting happens Friday. I'm not following the timeline there.
So, Jonathan Norman, for the record, thank you for the question. Again, I don't believe we are changing that from the current NRS. It's simply reorganized, and that's why it's in blue. And I could flip to the section, but if we're talking about the constables, if I can clarify the constables' 24-hour notice. So they have, and sorry, I don't know the days that they do go out. So I agree, it can put, like that lockout notice, 24 hours to 36 hours. I mean, I think it puts people in a precarious position, whether that's a Friday, Tuesday, or anything. And I think that how this bill helps alleviate that is by having the time period for the tenant to file an answer. And, at the end of the day, if somebody gets served a notice and a summons to respond and they don't, we can only do so much, right? And not that we're not going to try to help, like us legal service providers, those people walk in our door. Let's say we go with this law. Those people walk in our door, we're going to try to help them, right? We're going to do everything we can. But what I'm saying is this law is not seeking to change how the constable does their operation. So we're leaving it as it is. Thank you. Maybe a future bill if you're interested, Assemblyman Gray.
Thank you. And with that, could I just ask a question about clarifying the days? Because I know in the bill, there's times where it talks about, say, for instance, 10 days, and then it also refers to judicial days. Could you just give us a brief explanation on the difference between the 2 days?
So absolutely. Thank you for the question. Jonathan Norman, for the record. So justice courts have gone to counting calendar days. So in the bill, one of the, I think it's the, some of the notices say judicial days. That is one of the things we're working with stakeholders on. I think, and the reason it's important to go with calendar days instead of judicial days is, one, that's how justice courts are going, but not all justice courts are open the same number of days of the week, right? So if you have one justice court that's open Monday through Thursday, your judicial days hit differently, right? And so to make it fair across the board, and uniform, which I think goes a long way for clarity, we are looking to change it so that every counting within our proposal will go off of calendar days. So that's not reflected now. That's because we've got a lot of stakeholders giving wonderful input, and we're getting there. Thank you.
Thank you for that clarification. With that, our next question is from Assemblywoman Gallant.
Oh, thank you, Chair. Thank you for this. I mean, I can see the intent of trying to ensure that the tenants have an ability to be able to advocate for themselves. I'm curious, presenting as this being a quick process, I can attest that it's taking 4 to 5 months now to go through the eviction process, so it's far from quick these days. However, I understand that a lot of evictions are filed. Do you have the numbers on how many actual lockouts occur? Because those numbers are very different, at least within my book of, it's like very rare we get to that point.
Thank you for the question, Jonathan Norman, for the record. So I'm going to answer in two parts. I can get the answers on the number of lockouts. I think the constables, they report back to the county commission with their data on how many lockouts they're doing. So I can get that for you. I don't have that number right now. On the speed, right, and the summary evictions. So for context, you know, during the pandemic, we had we had historic unemployment and Nevadans struggling, right? And so our federal government, this body, stood up rental assistance programs. And so there's two things to acknowledge in there. It is fundamentally not fair for a summary eviction proceeding to take 5 months. You will never hear me say that that is how the process should work. So, and there is, I don't want to use the word trauma, but there is kind of a difficulty because landlords have been dealing with that, right? At the same time, when this body gave that and our state allowed for that rental assistance, it kept, just in Clark County, over 60,000 families in their home during the heart of the pandemic. Around the state, that number would be much higher. The counties stood up rental assistance programs that got $500 million out the door, which ultimately went into landlords' hands, right? And kept Nevadans in their homes and stabilized our community. So part of the problem, as we've heard echoed throughout this building, is staffing issues over the last several years. So while it was a Herculean effort to stand up those rental assistance programs, processing those applications takes time, right? And that requires being robustly staffed. The counties did an amazing job standing up those programs, and they saved a lot of Nevadans' homes. And I've talked with legislators who are landlords who have said this made a difference for tenants I worked with. And I would say that the process, the timeframes are going to come down, right? We are going to return to pre-pandemic timeframes. And the reason is the CHAP, which was Clark County, the largest rental assistance program that got, I think, $300 million out the door, it stopped taking applications on January 22nd or 23rd. I might be wrong about midnight. They are still processing applications, right? And so it's a double-edged sword. I can acknowledge that it put landlords in a really difficult spot, and I can also acknowledge that it did amazing things and kept Nevadans in their home, and the counties did an awesome job in rolling out that money. As we've seen in other committees, rolling out money that the IFC has designated and actually getting it on the street is difficult, as we've seen with children's mental health. So that they were able to do this, I think, is awesome. But I also acknowledge that it's caused delays. So, and to just bring it home, sorry, I'm going a little long. To bring it home, right now Clark County is operating 2 rental assistance programs. I'll speak to them because I'm most familiar with what they're doing. So one, and it's in the diversion court program, but one, if you're a senior or on disability and you have faced a rent increase in the last 12 months, and your income obviously hasn't gone up, it covers that difference. So that's one of the programs. The other program is if you are no more than 2 months behind on rent, and you had an economic hardship. That's a pretty loose definition, what an economic hardship is, but you have to show that you have the ability to pay ongoing rent. So if we get you right, if the county steps in and pays that 1 to 2 months, makes you whole, do you have the income to make your next month's rent? So that's what they're evaluating. And so I think those whole programs, we're talking about under $20 million for the year, and I would have to check with the county people to see if that number is exactly right, but I know that they were given $15 million from IFC, I think in October. And so when we're talking about a program that was rolling out $20 to $30 million a month, and now we have a program that's going to be doing, and again, the number, I might be off by a few million, which that's not insignificant, but when we're talking about $15 million to $20 million for the year, obviously our timeline on processing those applications is going to drop. Last time I checked with the county, those new programs, we're looking at 11 days from the completed application to a determination. And so I'm hoping 11 days, you're not going to get in front of a judge in 11 days on your normal eviction. So I'm hoping that, you know, those rental assistance programs that have created, that have kind of like made it difficult to talk about evictions, right? Because landlords had to deal with that 5 months you spoke about. I think I'm hoping that that's not an issue going forward. And I don't think it will be because of how rental assistance is functioning. Thank you for the 20 minutes.
We appreciate it, Mr. Norman, because again, this is a complicated matter, so thank you so much for your explanation. With that, our next question is from Assemblywoman Considine.
Thank you, Madam Chair, and thank you for this bill. We're in a housing crisis, and we've had questions today on judicial efficiency. We've heard about social programs. We've heard about having to match these two documents in the system the way it is. My question is in a way trying to bring that all together, because what I see this bill do is if it provides a clear way of doing this, a consistent way with other things, which then allows cutting through this, having to match two documents, having to do these other things, allowing counties to get realistic data on where we are, and allowing social service programs, when necessary, to step in, thereby hopefully cutting down the number of evictions. So bringing this all together, I guess my question is, do you see this bill and the results of this bill allowing counties to get realistic data to use in order to attempt to tackle or come up with different ideas to solve the housing crisis?
Thank you for the question. I agree with everything you said in the statement up to the question. I will co-opt that and sign off on it, because I do think a housing crisis we're in. I think that this, so, you know, a couple things. You know, the notices are not filed with the court, right? So we're still going to not know, you know, if you get a 7-day notice and you move out, did I say Jonathan Norman? Jonathan Norman for the record. If you move out in the 7-day period, we're not going to have that number. In our new system, we're not going to have that number. What we are going to have, I think, is more tenants engaging in the process. So we're going to have more accurate data in that we're capturing those tenants who are engaging and allowing social services to interface with those tenants earlier. And what I hear from the counties are the sooner we can get involved, the better. And so right now, you know, the same as when they get that, you know, 24-hour lockout notice that Assemblyman Gray referenced, that's when they're engaging with legal services. That's also when they're calling the county and saying, we need a housing option, right? And at that point, you know, you have rapid rehousing is extremely expensive for our local governments. 2, you're probably looking at a tenant losing all of their personal property because they are not going to be able to, like, just imagine, like, I couldn't imagine trying to move in a month because I'm like a secret hoarder, you know, but, it would just be impossible. And if you're somebody facing 24 hours, 36 hours, that window, there is no way you're going to be able to move your property. Anybody in this room, nobody would be able to do that. So the sooner we can interface, the better outcomes we have for tenants, families, and it gives opportunities for, you know, Las Vegas Justice Court piloted diversion court, and so, you know, if for those 2 pots of rental assistance I mentioned, those cases can be diverted to diversion court where the tenants are wrapped in social services. A fundamental problem in summary evictions with that diversion is, where is the time? Like, you need some meaningful days to make social services effective. And so while this isn't a lot of time, it's a lot better than where we're at. And I think having the normal flow of justice is good, where we have a complaint and a tenant and an answer. Thank you for the question.
Thank you. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for bringing this bill today. I think it really is an essential bill. I think it is important that we are acknowledging the housing crisis. We're acknowledging the humanity of the people that are being served with these notices. And honestly, through this whole process, I've learned that this is very confusing for everyone. And I can only imagine if I wasn't a lawmaker just looking at this dispassionately, but I'm somebody who is about to be evicted, who has kids, who is struggling because I can't pay the bill this month, and I don't have a nice handy little chart to tell me what my next steps are. And so I wondered if you could just speak to, whether you have numbers or whether you just have anecdotes of how many people you see that don't understand this process, that come to you and it's too late for them to do anything, or if you have any personal stories of what you have seen in this space with people reacting to this process.
Yeah, thank you for the question. And I don't have, Jonathan Norman, thank you. I do not have data on how many people of the 300 to 500 people that come in every day to the Civil Law Self-Help Center in Clark County are coming when they're at the moment where it's too late, right? They got the lockout notice. I know, and I could probably get the data for how many cases like our legal service providers take that are at that moment, but that would capture a small fraction, right? Because a lot of people, the bottom line is they, I would hope that they can all come in and get assistance, but the reality is a lot of tenants can't avail themselves of that for whatever reason. And I do think, I appreciate that you acknowledge that, when somebody gets this notice and they are in a moment of extreme crisis and they may have their job or a million other things piling up. And I think a lot of people can go into almost like a trauma response where they have such difficulty even engaging with the eviction. And I can say when we have clients regularly that come in that are at that lockout notice, and it is really heartbreaking to, I guess, deliver the state of the law to them, and that it is, the moment has passed, right? And we are doing the best we can and connecting them with social services. But yeah, I think it's real suffering there, because how our law is structured now, once they're at that point, there is not a lot that can be done legally. Thank you.
Thank you. Our next question is from Assemblyman Ornlicker.
Thank you, Chair, and thank you very much for bringing this important bill. I want to pick up on one of the things you said. One of the benefits of giving more time and more notice is they may be able to take advantage of rental assistance and avoid the eviction. And so that makes me wonder if it's possible, and maybe it's already being done, to make sure tenants who are at risk know about these rental assistance options earlier, so we don't even get to the notice. And so, for example, you mentioned if there's a rent increase and you're a senior, that triggers your eligibility for rental assistance. Does the landlord tell the tenant when they're notifying them of the rent increase, by the way, you may be eligible for rental assistance if this increase that I'm about to impose is a hardship? Do we have, or in the original lease, some kind of notice about rental assistance?
Yeah, I appreciate the question, Jonathan Norman, for the record. I would say that, that's on an ad hoc basis with landlords. Some landlords I know are really good about engaging with the tenant before there is an issue. So I think that there is nothing that I'm aware of that requires those types of notices. But I do know the most expensive cost for a lot of landlords is when they have this moment, like they want tenants who are paying their rent, right? Now we can have discussions about rents going up 20 and 25% and that, but that's not in this bill. But landlords fundamentally want tenants in their units paying rent, and I imagine there is a lag time of not just the time that it takes to get the eviction, but there's a lag time in actually getting the property relisted and getting a new tenant in there. So I think there is an incentive for landlords to let tenants know, especially if they work with elderly tenants about or people on fixed incomes about the rental assistance programs, and I think a lot of them do, but that's not, I'm not aware that that's anywhere that they are required to do that, but I do think they have incentives to do that, and every time a rental assistance program rolls out, I think a lot of landlords are first to engage. And then I would also acknowledge, whether it's the county or a lot of our community partners that are here in the room, they do a pretty significant public outreach to make sure that tenants know not only about their rights, but about rental assistance that's available. And I know during when CHAP rolled out in Clark County, we saw a significant increase in engagement with the judicial process from tenants, and I think that was driven in large part by the community partners that sit in this room and the county getting the word out, but I think we can always do better on that front.
Thank you. Our next question is from Assemblywoman Hanson.
Good morning. Thank you for being here. I actually have lived this. I think I've mentioned before that I was raised by a single mom, moved 17 times in 18 years, and know what it was like to be evicted, to have our furniture repossessed. But with that being said, what I'm curious to know is, at least from my experience, is we talk about the notice, we talk about this time frame. A lot of times, unfortunately, those of us have been in those situations, it's apparent that we're starting to get behind, that we're starting to struggle financially because of the circumstances, or we're living paycheck to paycheck. So I'm just curious, do we have data, and you probably don't have it today, do we know how overdue, do we have an average of how overdue a person gets before they're being evicted? Before this whole process, that they're going to have to, my kids and I are going to have to move?
Thank you for the question, Jonathan Norman, for the record. I don't know that data exists where, certainly landlords, and, I guess if you were really deep dove, you could, well, no, you couldn't do that because a lot of cases are sealed. I think you could look at, the Census Bureau publishes data every month about, and this wouldn't be case specific, but they publish data every month about how many tenants in Nevada are at risk for eviction. And so you could look at that data and over a year, right, you could say if in January 100,000 tenants were at risk of eviction, and in February it was 90,000, right? You could start to get a picture of where our state at a macro level is, and I can get you those, the links to those surveys. I mean, they're pretty illuminating on landlord-tenant issues, but also they cover everything from food insecurity. They cover not just evictions, but they cover how many people are current on their mortgage. So that might be illuminating for that question, but I don't know that there's data that's tracked unless, maybe landlords track it within their own communities just to understand where their tenants are at.
And just a quick follow-up, Chair, to what he just said. Thank you for that. And certainly, like I said, I'm asking the question, generally speaking, because maybe some of those in the audience, they have data from the spheres of influence that they're involved in. So I appreciate that. You mentioned at risk for evictions. Do we have what does that mean? Do we have a checklist of what an at-risk individual is so that we know what those warning signs are?
Jonathan Norman, for the record. Thank you for the question. When I said that, it was in reference to the Census Bureau survey that they do. So I do not know the questions that they are asking tenants in order to determine what at risk means. I mean, anecdotally, the things that I would be looking for are. Well, I don't know. The things that are kind of common sense is is the family living paycheck to paycheck, and those kind of like classic, economic questions. I certainly think that the Census Bureau has, on that website, you can see the questions that they're asking to determine when somebody is at risk. And there may be a bit of subjectivity in that if you're asked, in a survey asking, and I think they have a margin of error in their surveys that's, at the top. Thank you.
Thank you for that. We will return for a second round of questions, starting with Assemblyman Urick.
Thank you very much, Chair. And I'm grateful for the opportunity for another question. And really an opportunity to tell you, as I sit here and listen to both you, Mr. Norman, and Assemblywoman Summers Armstrong, your obvious passion and your heart to try to help the tenants, right, in this time where we are experiencing a housing crisis. I believe your intentions are absolutely noble, and I really appreciate that. And I want to make sure that you understand that as I ask this question, because my concern isn't so much with what your intentions are, but I'm concerned about the potential policy implications that can have, the incentives that this sort of policy might create. And let me put it in context real quick. I appreciate you saying that we're just going to bring this in line with other civil court processes. As somebody that practices in civil court, that process can often be delayed and, as we've already indicated, not real efficient. And I believe that's what the summary eviction process was established for, right? It was established to address the unique relationship between a landlord and tenants, which is based largely and most often on a month-to-month financial transaction. And so the summary eviction process was intended to kind of streamline that to resolve these sorts of disputes in weeks, not months. And so with that as kind of a context, I guess my question is, from a policy perspective, not intentions, but the potential implications of this, are you concerned that there might be a deterrent effect with this sort of process, where landlords might not be able to absorb the loss of income for the months that it might take to get through the normal civil court process, and therefore could unintentionally lead to less people willing to engage in these types of rentals, and then actually reduce the availability of housing at a time when we really need it most?
Thank you for the question, Jonathan Norman, for the record. I think this is good policy, and I'll tell you why. So one, I don't know that the idea that we are going to drive landlords away when we've seen 20 to 30% rent increases year over year. This is, even if we factor in inflation running amok, this is a sizable increase in profits, right? And if we're free market, we are not going to drive landlords away. I think that landlords see our ecosystem and see the opportunity to make a better life for themselves and their families, right? Because of the rent increases. Secondly, while we say that this is to get our procedure in line with all other civil procedure in this great state, but also I think in the United States, because I'm not aware of any procedure anywhere in our country that has this piece. That does not mean that the process tracks normal civil procedure. So, I'm sure you were thinking in your cases, are we going to have like lengthy discovery? Are we going to have, motions practice? This is still a summary process, and if you would have to file a formal eviction if you want to avail yourself as the landlord of all those little pieces of civil procedure, right? So this still will be a very fast process, tracking summary eviction processes in other states that are fast. And so I don't think, in what we're talking about, what slowed down the process, rental assistance, and the time it's taken to get money out the door, and then so we're talking about adding here, really, and the number gets a little squishy because it depends on how fast the court's turning around that order in our current process. But I think that can be up to 6 days. So if we look at it like that, we're adding 4 days. If we say they're turning that order around in, 3 days, then we're adding 7 days. So I don't know from a policy perspective, one, that we're going to drive landlords out of our ecosystem because there is a lot of money being made right now. And then two, I think adding those days from a policy perspective, when they're meaningful, so when the tenant can still avail themselves of the legal process and social services can get involved, makes a lot of sense. But I do appreciate that, we don't want this to be a process that drags out for months, and I don't believe it will. Yep.
Thank you for that. Our next question is from Assemblywoman Gallant.
Thank you, Chair. Wow, 30% increases. I wish I was seeing that on my end, but so one of the other process in this is that like the tenant files, so we have to file the complaint 10 days after the so we do the 7-day, we have to file the 10-day summary complaint, or we have to file the summary complaint, and the tenant has 10 days to answer that. It states there that the tenant has to be served with a stamp summary eviction, or the summary affidavit. Is that expected to be filed or sent by the courts, or is that expected to be processed and served by the landlord? So how do you see that actually rolling out?
Thank you for the question, Jonathan Norman, for the record. So 2 parts. I think if a tenant files an answer, the court is going to mail out the notice for the hearing date to the landlord and the tenant. So they're going to have that. For actually serving the complaint, that is going to be done by the landlord, not by the court, and it will be in the same manner. I think it's NRS 40.080 that governs service for our chapter. So it would be the landlords would have to serve the tenant.
Follow up on this process, please. So currently, right now, the law states that we have to pay a process server or the constable to post the 7-day pay or quit, okay? I also see that you've added that there could be a witness, which we got rid of 4 years ago. I'm not quite sure why that's being added in. However, so now we get this summary eviction or summary affidavit. Most of us do it online. We don't actually go to the courthouse and get that stamped copy. So now we have to hire a process server again to post that or serve the tenant. Is that what I'm hearing?
Jonathan Norman, for the record, yes. And for everybody to understand, I believe the constable, so you would have twice that notice is served by the constable. I think the language, just to address the language you referenced about the witness, I think that relates back to that short weekly thing, and we anticipate getting that out of the bill as we continue to talk to stakeholders. But you are right. It would require a second service by constable. And just for everyone on the committee, what that means for a landlord is I believe that in Clark County, it's $26 and $2 per mile the constable has to drive. If they're going to a property where there's multiple, where they have to do multiple postings, so maybe they have 6 units, or if they're in close proximity, then, I think it tiers down. So and I think it goes down to $16 if you have 10 or more units to be served on the same property, and the mileage can only count once. So yes, that is an additional cost.
Okay, so you expect rents to be affordable while you're increasing the costs on the landlord. That's good for everybody.
Assemblywoman.
Thank you.
Next question from Assemblywoman Cohen.
Thank you, Chair. I just want to get into a little technical section of the bill. In Section 2, on page 5, I don't even know which sub it is, line 18, the days of service with that definition, where it's got the date, but it divides up the date as whether notice is delivered before noon or afternoon. That was a little unusual to me. Is that, what's the basis of that? I mean, I guess that's talking about service of notice to the tenants by the constable and not for service with the court. But yeah, could you address that?
Jonathan Norman, for the record, thank you for the question. I believe that language is what exists in statute. I could follow up with the court and constable's office as to why we have it laid out that way, but our bill is reorganizing that, so that is not a new section to the Chapter 40. That is how it is in current statute. Thank you.
Follow-up?
Yep.
Okay, and then, she was asking me,
Sorry.
actually.
Yeah, I know.
Well, thank you. But thank you, Mr.
slow on the
Norman.
uptake, sorry. I apologize, Chair.
And, okay, and then maybe if that might be a little confusing, if there are some amendments that if we could look into possibly just.
Yeah, I
if
think
it might be easier just to start it the way we do with regular civil procedure, where you start counting the day after service, if
I
that's
think-
a possibility.
Thank you. I think that makes sense, and I know that the constable's office is, you know, they're one of the stakeholders because they have timelines in this statute. So I know we're looking to have input from them, and so maybe they have some ideas about that section. Thank you.
Thank you for that. And to be very transparent, all of us struggle with the same thing whenever we're in a room and someone says, all those in favor, and like we're in the hallway and I just comes out, right? So I appreciate that. We actually do have a few final questions. Maybe some of you notice we have a guest with us on the dais today. So Speaker Yeager actually has a few questions for you today.
Thank you so much, Madam Chair, and thank you for allowing me to sit in today. It's nice to be back here, and thank you, Assemblywoman Summers Armstrong and Mr. Norman, for presenting what I think is often a difficult concept. A couple of questions I have, and really it's just to make sure I understand what we're trying to do in the bill, and this sort of dovetails with Assemblywoman Considine and Assemblywoman Gallant's questions, and that's a question about data. I think one of the issues we've had over the years in this committee is it's hard to know how many people, I don't want to say being evicted, we know that, but how many people are getting served with these notices and vacating the premises or remedying the problem. So the way I understand this bill, the process of putting the notice on the door, the pay or quit notice, I know there are other ones as well, but that process is going to remain the same, and the complaint will be filed at the expiration of that process. So we're still not going to get the data about how many people voluntarily vacate the premises, but, so I'll make this a two-part question. Once the complaint is filed, if this bill were to be passed, we will get some data, I think, how many people at that point vacate the premises versus the court being required to actually issue a summary eviction notice. And so I want to ask if that's correct and if there's some value in having that data, that what happens after the complaint is filed. Does it actually get to a hearing? Is there an answer filed? Does the court have to do something, or does the landlord just come in and ask for a voluntary dismissal?
Thank you for the question, Jonathan Norman. You are right that we will not have information on the notices. We are not changing that. Would I love to have data on how many people are leaving their homes? Absolutely. I think that could be really informative for policymakers, but I think that creates a lot of practical barriers, right? I know I've discussed with Las Vegas Justice Court, like could those notices flow through the court and then back? And I think that would, well, one, I don't know that we know how many of those notices there are, but I have just anecdotally in discussions when we were going through diversion court, I think, you know, in Clark County, 10%, around 10%, and this is anecdotally, in talking with stakeholders, that about 10% of the universe of notices that are given every month become filed eviction cases. And so when you think about that number, if we have 2,000 to 3,000 evictions filed in Clark County, and that's 10% of the properties that are getting notices, I think it's would overwhelm the judicial system to try to process those. I do think, to the second part of your question, I think having the complaint as the first piece filed that is served will increase tenant engagement. And so I think we will get data in you know, we'll know the number of eviction complaints filed. We will know the number that get an answer, and we will be able to, you know, it would take I don't think it's contemplated, but understanding what happened. Because some people may cure in that period, right? And the landlord may work out, or they may work out a payment plan. So I don't think we'll know, like, did they self-evict or did they cure? But we'll be able to match up, like, how many tenants engaged after receiving the complaint. And I would anticipate more tenants engaging, and I think there will be value in that. And we will have data, that's better than what we're working on now.
Thank you. Could I ask one follow-up, please?
Yes, please.
Thank you, Mr. Norman. And to be honest, I was originally a little concerned that we were going to do away with the 7-day pay or quit, and all of those were going to go to court. And as you mentioned, the volume would be probably catastrophic for the court system to be able to handle. So thanks for taking care of that. The only other, I guess maybe it's a question or a suggestion, but on page 3 of the bill, this is section 2, subsection 5, we talk about the affidavit that has to be filed. And there are certain things that have to be included in that affidavit. And I think some of that's going to be valuable information, right? The date the tenancy commenced, I think that's going to allow us to figure out, is this a monthly? Is this someone who's been in the property for years? And the reason I say that, I mean, we hear a lot of anecdotes in this committee around this topic. I think there are good actors and there are bad actors in this space. And I think we have to acknowledge that. I think this may help us figure that out. But my suggestion, I suppose, here's the question is, when the affidavit is filed, is there going to be a tie-in there to the eviction diversion court process where this would be a way to sort of try to find folks who might benefit from that program? So that's the question. And then the suggestion would be, I think this affidavit could be a very valuable tool for obtaining some of this data that we would like to see. I don't have anything specific, but as you work through this process, I would think about if there are other things we could ask the landlord, things that they could easily put in there. Are there things that we could ask them to put in there to help with the data collection? One example would be, are there children living in the property, or is it just an adult landlord, to the extent that they would know, because I think that would help us get a real picture of who it is that's facing eviction and how we might be able to bring in social services to help with some of these issues. Because some of these people will be convicted, and some of them should be convicted because they're not able to comply with the law. But it'd be nice to have that entryway and, entities actually communicating and looking at this information to proactively reach out to help some of those families.
Jonathan Norman for the record. Thank you for the question and suggestion. I will say that, so right now how diversion court functions is the tenant answer and the only diversion court I'm aware of is in Las Vegas Justice Court right now. They do handle 70% or more of the evictions in the state. So the answer that, and I think the local rules were amended so that that is the answer that has to be used. And so that answer contains questions that allow for the court to evaluate the case for diversion. So for example, we're looking for people on a fixed income for that one program I mentioned earlier. So there's things in the answer that route the case. And actually the only way to get in diversion court is to, answer those questions correctly. And I think, insofar as it makes sense, I think it might, because it might be difficult to have it in the statute, because I'm just thinking through, the criteria for different rental assistance programs are going to vary. So we would have to cast a pretty wide net to encompass, because have you had an economic hardship is only for this one discrete program. And, if there are other programs around the state, we'd want them all. And so maybe that would belong naturally in local rules and in the forms we use. But I do really like the idea of adding, data that would be informative for policymakers into statute, whether it's the age of the tenant, if we're talking about elderly people, or certain information that would be useful to have data on. I think that could really go a long way in informing the state. And then insofar as we can capture things that would be criteria for rental assistance programs, because, rental assistance programs they should be targeting mostly our most vulnerable. And depending on how big our pools of money are, we can probably understand at a macro level, those are going to hit seniors, people with disabilities on a fixed income. If we could get to families with kids that are at risk of being homeless and then entering child welfare systems, those are what we're talking about when we're talking about vulnerable tenants. So maybe at a macro level, we could guide that in statute. And then if there's any, boutique rental assistance program that doesn't go off of those data points, that could be in local rule or statute. So I think those are good ideas. Thank you.
Thank you, Mr. Norman. Thank you for the time, Madam Chair.
Absolutely, Speaker. And with that, we have concluded our questions. I know that there's a number of people that are going to be testifying on both positions, and so I ask that everyone keep their testimony brief. But I would actually like to start in support, but would like to start down in Las Vegas because I see some people there, and I'm not sure how many are in that little room. So to accommodate them, let's start in Las Vegas. So there in Las Vegas, are you here to testify in support of the bill? Are you here to say something about the bill? Yes, please have them come up. Thank you. And so again, I'm opening it up for testimony for anyone that would like to testify in support of Assembly Bill 340. So please proceed. And make sure you say your name and please spell it for the record as well so that we have it accurate. Thank you.
My name is Kimberly Ireland, spelled Kimberly. Last name Ireland, Ireland. I work at the Mirage Hotel, and I am a proud member of the Culinary Workers Union, Local 226. On January 31st, I was forced out of my home. January 31st of 2023, I was forced out of my home, and the eviction was granted. This was totally devastating for my family. I have 2 adult children. I have a grandson. It was totally devastating for us. About a year ago, I tested positive for COVID. I have not been able to go back to work since then. During that time, the CHAPS program, the rental assistance program, they assisted me and my family since I've been out of work. But once the funds exhausted, my landlord no longer wanted to work with me. So that put us pretty much in the position that we were in with the eviction. And since then, it's been very challenging for us to find a new home. We've bounced around from weekly rentals to short-term rental. We've lived with family since then. And I can assure you that this is something that I would not wish this eviction process on anyone. And so I am here today to say that it is imperative that we do something. Something about this eviction process needs to happen differently. Thank you.
Thank you for sharing your story.
Good morning. My name is Angela Escalera, Angela, Escalera, Escalera. I am a mother of 6. I am a happy member of the Culinary 226. I am a mother of 6, and I have a granddaughter. I was living in a studio. I was paying $1,000. For the reason why I got sick too when I was last year, I was positive for COVID as well. I got off of work. I was not working for a while. All I had was my savings. Because of the size of my family, it was hard for me to find a place where to go, either my credit or they wanted, I didn't have no more income. At the moment, I just had my savings. So I was stuck in the studio I was paying $1,000. All of my savings were running out. All I know is, thank God I went back to work. One day my daughter calls me, tells me, Mom, the landlord and some guys are here. They're knocking on the door. They say we have 5 minutes to get out of the house, and just to pick up whatever we're gonna pick up. And I'm like, what's going on? That day was raining. I remember it was a Thursday. I remember I just say, I was really gonna start my shift when I tell my kids I have to go. I pick up my kids. They're all crying in a car seat. I didn't even know what to do at the point. It was really hard, And right now I'm just, because of the size of my family and because of either they want double the rent, there's always something to it, is it my credit, want more deposit? So it's been really hard for me, So I just wanted to ask, I tried to go to the courts. The court says, for the reason being, they did not grant it. I lost it. It was unsuccessful. So because I needed more, Nevada needs more eviction, refunds now.
Thank you. Thank you so much for your story and for your support of the bill. Is there anyone else there in Las Vegas that would like to testify in support? Is there anyone coming up? Okay, thank you. All right, with that, then we will come back to Carson City, and I ask that everyone keep their testimonies brief to 2 minutes. And when you're ready, please proceed.
Good morning, Chairwoman and members of the committee. For the record, my name is Susie Martinez, and I am the Executive Secretary Treasurer of the Nevada State AFL-CIO. And on behalf of over 150,000 members and 120 unions, we are in full support of Assembly Bill 340. All of us are here today. We know that that Nevada is facing a housing crisis. Many working families across the state have to stretch dollars in order to ensure that they can keep a roof over their heads. The stress of a possibility of losing one home is hard enough, and tenants shouldn't have to deal with confusing legal processes on top of that. This bill will critically put the eviction process in the hands of the landlords rather than tenants themselves, reversing the backwards procedure that has put undue responsibility on tenants for far too long. I'd like to thank Assemblywoman Summers Armstrong for bringing this bill forward, and I urge the committee to support Assembly Bill 340. Thank you for your time.
For the record, my name is Mark Ellis. I'm the president of Communication Workers of America, representing close to 1,100 members throughout the entire state of Nevada, and we are in full support of this bill.
Thank you. And just a reminder for everyone to spell their name as well, please.
My name is John Solomon, JOHNSOLOMON, and I am a member of Faith in Action, and I support AB 340. As a member of the Reno community, I find homelessness unacceptable. Our society is bleeding, and all we're doing is cleaning up the blood. The passage of AB 340 will help stop the bleeding by making it more difficult to evict someone. Someone who is evicted with just 7 days' notice is very likely to become homeless. My faith teaches me compassion. This bill will not cure the problem, but may result in fewer evictions because it will give tenants a more reasonable amount of time to either come up with the back rent or find a new place to live. I work with homeless people, and a part of most stories is an eviction, usually through no fault of their own. As a landlord, I know that in every other state, landlords somehow manage to make lucrative incomes despite tenant-landlord law being very much as AB 340 provides. It isn't a radical change. What is radical is the eviction process as it is now in Nevada. As a landlord, for me, eviction is a last resort. That is not true for many landlords. Instead, it's a knee-jerk reaction to any landlord-tenant problems or a way to get large increases by turning people out and getting more lucrative tenants. Not allowing summary evictions may also make landlords communicate better with tenants instead of the atmosphere of fear that now exists. An eviction is a lose-lose situation, bad for the tenant and the landlord. AB 340 is not, I repeat, AB 340 is not an undue burden on my business. Thank you for my time and consideration.
My name is Paul Catha, and I represent the Culinary Workers Union Local 226, and I am also glad that I don't have to follow Maggie Carlton. The COVID-19 pandemic hit culinary union members and their families incredibly hard. While many hospitality workers have returned to work, culinary union members have not recovered from the effects of the pandemic, and thousands are still struggling with housing insecurity. The culinary union is a member of the Nevada Housing Justice Alliance, and we thank Assemblywoman Summers Armstrong for working with the NHJA on this bill. In a 2022 survey of culinary union members, 21% said their rent had gone up $500, 21% said that they are charged charged fees in addition to rent, 15% said that they pay more than $100 in fees each month. Rent increases have outpaced wage growth from the first quarter of 2019 through the second quarter of 2022. Market rate rent in Las Vegas increased 33.1%, while average weekly earnings only grew 21.4%. In 2021, investors bought 18% of homes in the Las Vegas metro. In some areas of the metro, investors purchased 26%, over a quarter of homes sold. According to the January Census Bureau's Household Pulse Survey, 49.8% of adults in Nevada said they struggled with paying household expenses in the last 7 days. In the first weeks of January, Las Vegas already had the highest number of eviction filings in the country. Out of most major cities, Nevada must change the filing order for summary evictions because tenants should have the right to due process when threatened with losing their home. Nevada's summary eviction process is unique in the United States, and it's the only civil procedure in Nevada that operates in this way. Nevada requires tenants to file the initial notice with the court. This is bad and confusing public policy, which negatively impacts Nevadans and culinary union members. Every Nevadan deserves an affordable and stable home, and an eviction should never be a surprise. Working families and people of color are disproportionately impacted by housing insecurity, and the culinary union believes that every Nevadan deserves to be treated with dignity and respect. Nevadans shouldn't have to choose between putting food on their table and having a house. The culinary union urges the committee to support and pass AB 340. Thank you.
And thank you, Mr. Cathan. We appreciate you not wanting to go after our former senator and assemblywoman, which is why I saved Speaker Yeager's questions for last as well, right? With that, Ms. Carlton, and it's good to see you back here.
Thank you. And Madam Chair, I'd be happy to recuse myself and let everyone go forward and then be the cleanup hitter for you if you would like.
That is absolutely up to you.
So thank you, committee, very much, and thank you to the Assemblywoman and to Legal Aid for all the work that they've done on this issue. For your record, my name is Maggie Carlton, M-A-G-G-I-E, Carlton, C-A-R-L-T-O-N, and today I am here in my capacity as Executive Director of the United Labor Agency of Nevada. During the COVID crisis, United Labor Agency, otherwise known as ULAN, did not close. We stayed open. We were one of those trusted, vetted partners with Clark County that helped people get their rent paid. Assemblywoman Considine said it very, very well. We are in a housing crisis, but we're also in a homelessness crisis. And the way to keep people from becoming homeless is to keep them in their homes and to help them pay their rent and to walk them through this process. You know, I'd read legislation for a very long time in this building, and when I had to sit down and read that portion to be sure that I understood it, when I was helping walk people through this process, thank goodness I had friends at Legal Aid to help me through it because it was very, very confusing to myself and to everyone that calls. In our office, we've actually had to turn our phones down to almost silent because they do not stop ringing. And it's for food and it's for housing. And people just don't understand that when they get that notice on the door that they need to act quickly. They all think naturally, I can fix this, I'll figure a way out. And they don't call you till a day or two before it actually happens. And the first thing we tell them to do is go down and file that response. And as soon as they file that response, we do an application with them. During the height of COVID, the volume was very unmanageable. Yes, it was taking 4 to 5 months, but that's because we normally only had maybe 10 or 12 clients a week. We were getting 100 faxes and requests a day for rental assistance from the community in Las Vegas. So it was overwhelming for everyone, not just for the nonprofits in Clark County, but the justice system also. So I know, the ultimate goal is to get the landlord paid. Most of the clients that come to ULAN, they want to pay their rent. They want to stay where they are. They don't want to move. They're tied to that community. Their kids are going to that school. They don't want to have to pack up and leave. So by giving us, as far as nonprofits, this bill will give me more time to help folks. I will have that extra week or so to get them processed. And you, Lan, if you have an eviction notice, we bump you to the top of the list. We do have folks that come that just need assistance that haven't gotten that eviction notice yet. They're being proactive and they're trying to be responsible. But if you have, we try to put you to the top of the list to make sure. And when I talk to the landlords, most of them are willing to work with us. They're like, okay, if you can give me just a little bit of assurance that I might get paid, I'm more than happy to work with you. Unfortunately, some of the out-of-state landlords have not been as accommodating. But most of the landlords in Las Vegas have worked really well with us. And I'll tell you, as far as getting referrals, as the Assemblyman mentioned earlier, once I've helped one landlord, they start telling the other tenants who to call. So when I say, well, who referred you to us? It's not a friend or neighbor, it's their landlord sending them to us to get assistance because they're willing to take our check. That's the goal, is to get a check to cover that rent. So I'm very happy to see this bill. I want to thank the Assemblyman again and Legal Aid Services. We have to straighten this process out. We have to keep families and children in their homes, in the school that they're used to. And this, I think, will really help with the homelessness issue in the future. So thank you very much, Madam Chair, and happy to be here and back in the building.
Thank you, Ms. Carlton.
Hi, good morning, Madam Chair, members of the committee. My name is Silvia Buenrostro, Silvia Buenrostro. I am a member of the Culinary Union and organizer for many years. I just like to share my story for those who have never been evicted, so I can walk you through all the letters that an eviction notice might bring, and the person is not able to understand it. And about 10 years ago, my younger son, who was 7 at the time, had an asthma attack. I'm a single mother of 5, and I had to stop working because I had to be in the hospital with him for that time. I've got great medical insurance, a good steady pay, but I was never aware that this process was to happen. I talked to the landlord who was out of state, and he said that I had to talk to his attorneys. They only said that I had a 7-day notice posted in the door because they wanted me to pay them. So I struggled and I got the money together. Next thing I know, 24-hour notice came up. I had no idea what to do. I called the landlord again and I said, look, I don't know why I got this notice. I don't have a place to go. Just came out of the hospital with my son. And he said, talk to my lawyers. I can't talk to you. They say you have to go to the court. So Friday morning, 8 o'clock in the morning, I go to the courthouse with the cash money. I did not know what process or what I had to do. At the moment, I'm there with the clerk to make the payment of my rent. My daughter calls me and she says, Mom, there's a constable at the door. There's someone at the door breaking in. And I said, well, look at the window and see who it is. She says, it's a police guy. I don't know. He barged into the door, yelled at her, and told her, get out of the house. It was winter time. My son just came out at the hospital with asthma. And they were thrown out with no regards. It's been over 10 years, and it still hurts. And I've been renting ever since then because I lost my house in 2009. And this process has to change. This has been way too long for all of Nevadans and everybody who has to rent to go through ignorant processes that we have not been informed. I had applied when I received that 7-day notice for rental assistance, and that process takes longer than the eviction. And of course, we end up homeless. And it is something that haunts you for life, and it's not easy to recover, especially with the children. They're always afraid, that if we are short in any kind of way, that we're going to get an eviction notice. So I really appreciate your time, and I support this bill, and I hope you do as well, so that Nevadans can have peace of mind and have a place to live and a roof over their head. Thank you.
Hi, good morning. My name is Aishika Paisley, Isheika, Paisley, Paisley. I am here today to show my support for AB 340. I am part of Faith in Action as well. I am a resident of Reno, and I live in Assembly District 24, why does this bill really matters to me? I was effect at one point, so it is very important for me to see the bill change. I can remember before my rent was coming up, sent my landlord email asking them if they could give me some time to pay my rent. I was waiting back for their response, and I have not received a response from them. Then I reached out to them and I said, hey, I did email you guys asking you guys for time to pay my rent, and I did not receive anything from you guys. What's going on? They were like, well, we cannot do nothing again because there's an eviction letter out for you. I'm like, how do you guys send out an eviction letter when I did ask you guys for time? So unfortunately, I wasn't at home at that time when they sent the eviction letter to my house. I was already 4 days out of my eviction. I didn't know what to do. I am a single mom. I have a son. And when I found out, then I run to the court, to the Sarah court, to for assistance, for them to help me with that eviction notice. On top of that, I didn't know I have to pay a fee because I have barriers getting jobs. I cannot work. I am not allowed to work and all of that. So I still have barriers. So I'm asking you guys for your strong support in changing this situation. This summary is not good for people that, especially that have barriers like with jobs and all of that. So I'm asking, and also people don't know that they can go to the court to get assistance with their summary eviction letter, and also they have something like the Washoe County can help you to do the waiver. Thank you, and again, I'm asking for your strong support in this.
Thank you. Hi.
Good morning, Chair and committee, members of the committee. My name is Chastity Martinez. That's CHASITY MARTINEZ. I'm here to express my support as well for AB 340. I'm a resident of Reno in Assembly District 27. I also work as a community organizer with Faith in Action Nevada. We organize both with faith communities and also with those that are directly impacted by issues of economic injustice and racial injustice. And we're also a member of the Nevada Housing Justice Alliance, and we believe that housing is a human right, or it should be. And we believe that those closest to the problem should be really at the heart of finding the solution. So I just want to uplift the stories that were shared today, the facts that you heard, in support of AB 340 and reforming the whole summary eviction process. And I urge you to support this bill along with other humanizing approaches so we can ensure that we can prevent further housing insecurity for our most vulnerable neighbors. And thank you to Assemblywoman Summers Armstrong for your leadership on this bill.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINESAUNDERS. And I'm the Policy Director with the Progressive Leadership Alliance in Nevada and a founding member of the Nevada Housing Justice Alliance, here in support of Assembly Bill 340. First, we want to thank Assemblywoman Summers Armstrong for bringing forward this important bill that we discussed in detail during the interim. Every Nevadan deserves an affordable and stable place to call home, yet the current summary eviction process allows landlords to entirely sidestep the judicial system when trying to evict residents from their home and places the burden on tenants to initiate a court case, should they hope to have the due process of a court hearing and judicial oversight afforded to tenants across the nation. Evictions and economic displacement impact us all by putting more economic burden on our communities through increased demands on social services, shelters, and hospitals by families who become homeless, and other costs associated with the disruption caused by housing instability. By contrast, stable homes promote educational opportunity for children and economic opportunity for families, allowing Nevadans to save for a house, pursue new employment options, and open a new business. During the past 2 years, our coalition has conducted community outreach, put on educational trainings on tenant law, assisted in filing for CHAPS, and in responding to summary eviction notices. However, far too many times when a tenant was finally able to be connected with us for support, the time had run out on their summary eviction. Sometimes we even had to help them move. This is inexcusable. The time is now to update our summary eviction process, and we urge your support of this bill. Thank you.
Good morning, Chair and members of the committee. My name is Lilith Barron, Lilithbaran, and I'm with the ACLU of Nevada. I think that this is an incredibly important piece of legislation that we unfortunately had the opportunity to do something about in the previous session. As we heard Mr. Norman say, there have been about 150,000 people, conservatively speaking, if there were 300 people a day, for the last 2 years that have come through his doors to try to address this problem, and I can assure you that 150,000 of those people were not housed after coming through those doors, which makes this the #1 bleeding artery for homelessness. If we do not cauterize this wound, we're going to continue seeing it affect all of the other areas of our community. We've heard things relating to education where there are school discipline issues. A lot of that sprouts from housing insecurity. We talk about reentry, how difficult it is for these folks coming out of the carceral system to find housing. A lot of that comes from housing insecurity. Food insecurity. These things will never end if we do not make smart choices like this one, and this is a very easy step in the right direction. I would also like to note that in Washoe County, it does cost the tenant $71 to file, and you must do it in person. We do not have an online system. I'm also the board president of Reno Initiative for Shelter and Equality, which is a family and senior shelter, and I can tell you most of our families are in the shelter because of the summary eviction process. And landlords are going and turning around, using this as a tool to then double, triple the rent that they were receiving before. This is not something that is affecting people who are landlords becoming homeless. That is not what's happening to them. They're not going to social services because they're not able to evict people. However, the people they are evicting are going directly to these social services to find security. So please pass this legislation. Thank you.
Good morning, Chair, members of the committee. My name is Serena Evans. I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. The conversation of housing justice is not just about tenant rights. Housing justice plays a much bigger and critical role in the prevention and intervention of domestic and sexual violence and the overall safety of our communities. Summary evictions are burdensome for tenants and require them to engage in lengthy and confusing legal procedures, only for them to be evicted, forcing them to find new housing in an impossibly short time. This process puts tenants at extreme risk for becoming homeless and for victim survivors, potentially pushing them back into the arms of an abuser, both scenarios directly increasing risk for domestic and sexual violence. The #1 request we see from domestic and sexual violence victim survivors are for emergency shelter and rental and deposit assistance. Our direct service providers have also shared that their clients are being served sudden evictions following instances of assault in the home. Experiencing violence should not be a cause for eviction. Housing justice is violence prevention, and we urge the committee to pass this bill. Thank you.
Good morning, Chair and members of the committee. For the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. We are here today in strong support of AB 340 to reform the summary evictions process. The summary eviction process has been abused against Nevada tenants for far too long. During the COVID-19 pandemic, despite state and federal eviction moratoriums, we saw corporate landlords trying to kick families out on the street during a public health crisis. I personally helped Nevadans who had to navigate this complicated process while running a community food pantry out of my garage. I have seen the damage this process can cause firsthand. It was disgusting, but sadly allowed to happen due to unscrupulous landlords taking advantage of the summary evictions, knowing their often low-income or otherwise vulnerable tenants would be unprepared to respond without outside resources or legal assistance. All Nevada tenants deserve a chance for an eviction hearing. Tenants should have access to resources and interventions when coming to court and should have adequate time to find new housing. The current summary eviction process does not allow this, but if passed, AB 340 will be a strong step towards giving tenants their fair opportunity to defend themselves, or at the very least, to find a new living situation before they are evicted. We thank the Assemblywoman for sponsoring this bill presented today, and we urge your support. Thank you.
Hello, my name is Erica Minaberry. That's ERRIKAMINABERRY for the record. I am here representing my 3 children. In 2018 and 2019, I was separated from them for 18 months because I had to relinquish custody due to the housing crisis. I simply could not afford to house them. I clawed my way up and out of that hole and was able to be reunited with them when I got a summary eviction in the summer of last year. And let me tell you, the trauma-induced panic that incurred during that time was almost almost made me non-functional. But as a single parent, I had to move me and my 3 kids, find a new place, and I had to do it all by myself without any assistance because the wait lists were so long, there just wasn't enough time. I maxed out my credit cards trying to pay for application fees, only to get the word that that place had already been rented immediately. And I was running out of time, and I was staring down the barrel of being separated once again from my children. My family has been traumatized by this, and we still are. We are still scared that the new place that I have, they could up the rent, they could give me another summer eviction at any time, and I'm paying too much in rent to actually have a savings, so I won't have anything to help me if I do get another summer eviction. The biggest tragedy that happened during this time, though, was that this all happened for me during the primaries of last summer, and I was plopped into a new district that I wasn't educated about. I had no idea who the candidates were. I was a super volunteer for a primary candidate in my old district, and I wasn't even able to vote for them because the housing crisis is a covert way of voter suppression. Make no mistake, the people that knock doors for all of you are knocking doors because of the housing crisis, and it makes it incredibly difficult to knock doors for a candidate when you don't have a door yourself. And it is true that in sessions past, there has been opportunities for you guys to help us, and you guys haven't followed through, and we need your help now more than ever, and we are all watching, and we are all voting. Please help us. Thank you.
Thank you for your testimony. Is there anyone else here in Carson City that would like to testify in support? Okay, not seeing any. Then I will open it up for testimony in opposition. Let's start in Las Vegas. Is there anyone in Las Vegas that would like to testify in opposition of Assembly Bill 340? Oh, I'm sorry. One moment. Not seeing anyone in Las Vegas for opposition. Before we start opposition, we need to go to the phone lines. So our phone number for today is 1-888-475-4499, and the meeting ID is 874-3382-1024. Broadcasting, will you open the lines for support, please?
To testify in support of Assembly Bill 340, please press *9 now to take your place in the queue.
Good morning, Chairwoman Miller and members of the committee. For the record, my name is Liz Sorensen. That's LIZSORENSON. I'm the president of the Nevada State AFL-CIO, and I'm here today in support of AB 340, and I urge the committee to support the bill as well. Thank you so much for your time.
Good morning, Chairwoman Miller and members of the committee. For the record, my name is Sue Bird, SUEDIRD. I am a senior on a fixed income living in the rural. This process is very complicated. I can't imagine trying to figure it out by myself and having to go to someone to help me. I am here today in full support of Assembly Bill 340, and I beg you, please support the bill as well. Thank you.
Hello, my name is Adrian Lowry, ADRIAN LOWRY. Thank you for the opportunity to testify in support of this bill. I just want to agree with all the previous comments and say, thank you. Please support this bill. Please pass this bill. Thank you. Bye.
Good
Good morning, Chairwoman Miller and members of the committee. My name is Renee Ruiz, Renee, and my last name is spelled Ruiz. I am the legislative advocate for National Nurses United in NOC, Nevada. And unstable housing and the stress of eviction is a public health issue and a public health crisis. We stand in full support of Assembly Bill 340, and we urge the committee to support as well. Thank you very much.
Good morning, Madam Chair Miller and members of the committee. My name is Shelley Speck. That's SHELLY SPECK, and I am providing testimony today on behalf of the Children's Advocacy Alliance and the Nevada Strong Start Coalition. In order to prevent families from slipping into homelessness, we must ensure tenants are given clear and concise instruction on how to respond when receiving an eviction notice so they can take appropriate corrective action. Since evictions have become commonplace statewide due to a lack of oversight and competition for properties, tenant protection is needed now more than ever. Summary eviction notices are issued to tenants by landlords without court involvement, and this creates a chaotic situation where tenants are at times unable to navigate the legal jargon of the eviction notice to be able to address it. Within a short allotted time frame given, tenants must file an affidavit in court to contest the eviction before the landlord files anything. Many tenants simply give up, resulting from a misunderstanding of the process. They self-evict and then languish on waiting lists in limbo for alternate housing. The stress of such a complex process affects families and children. By streamlining the summary eviction procedure, children will have a better chance of achieving stability and successful outcomes when they are less likely to be thrown out into the streets. It is unimaginable that families were evicted so easily this past year in northern Nevada during the coldest winter in the last 50 years. When we can first secure housing, then we can ensure the health, safety, and well-being of children. Ask yourself, what can I do to prevent another child from entering into homelessness due to unfair practices? When you leave here today, please make a commitment to repeal, revise, and reorganize the summary eviction procedures in existing law and support AB 340. Thank you.
Hello, my name is Gerald Mays. For the record, that's GeraldMayes. And I'm a veteran of the United States Marine Corps, and I'm testifying in my capacity as the chair of the Veterans Affairs Committee for the NAACP in Las Vegas. I'm here to urge you to take action to address the issue of summary evictions in Nevada. This practice is detrimental to the well-being of our veterans and all Nevadans. One of the biggest problems with summary evictions is that there is no way to involve critical social services or achieve early intervention ahead of proceedings, which can lead to a rapid instability for tenants. The eviction notices themselves are complex and difficult for the average tenant to understand. This creates a burden on tenants to initiate court action against themselves as defendants, which is counterintuitive and unlike any other civil court action in Nevada. The impacts of summary evictions are severe, forcing tenants to find new housing in an unreasonable short amount of time and putting them at risk of losing their jobs. This instability can lead to transiency for many families, negatively affecting access to health and social services, student outcomes, and ultimately increasing the risk of becoming unhoused. All Nevadans, including our veterans, deserve the chance for an eviction hearing. Tenants should have access to resources and interventions when coming to court and should have adequate time to find new housing. I urge you to take action to ensure that our most vulnerable populations are protected from the devastating impacts of summary evictions. Thank you for your time and your attention on this critical issue.
Broadcasting, do we have any additional callers?
Yes, we do, Chair.
Okay, thank you.
Good morning, Chair and Vice Chair and the committee. Sorry, I was looking for my unmute button. This is Dora Martinez, representing the Nevada Disability Peer Action Coalition, and I would really, I appreciate everybody's comment, and I agree with everyone's. As a blind person who got evicted when my youngest daughter was under 10, and being evicted and being served with a inaccessible format of communication, it was troublesome for me. I didn't know what was going on, and I was really scared when people showed up at our door. So I appreciate the sponsor to this bill, and I hope that it is inclusive and accessible from the get-go, baked into the bill, so anyone with different type of disability will get their reasonable, adequate communication in regards to their disability. As a blind person who is helping another blind lady who got evicted and had to get a U-Haul and find a driver that can drive because, I'm hazardous to the streets. It was very difficult. It was doable. It was just difficult because our needs was different than a person who, can go get a U-Haul and move out. So thank you for the sponsor, and I appreciate all of you. Have a great day. Thank you.
Good morning. My name is Falasha Perlin Watson. For the record, that's Falasha, last name PARLIN-WATSON. I'm speaking to you today as a member of the NAACP Unit 1111's Political Committee in support of Assembly Bill 340. As an organization whom community members often reach out to when in need of help, our members are regularly contacted by folks who've unfortunately already received a lockout notice, having not realized that they must file an answer to the 7-day notice. Many of these individuals, having not grown up in Nevada, are dumbfounded when they learn that the impetus was in fact on them and not on their landlord to begin the court proceedings in order for them to receive their day in court. This widespread misunderstanding of the process and the extremely short deadline it imposes leads to unnecessary evictions, both of those actively in the process of coming up with the funding to get caught up and those with legitimate landlord-tenant disputes, such as those intentionally withholding rent in order to compel their landlords to make statutorily required repairs. We strongly urge you to support this bill in order to help decrease the confusion caused by the current process and in turn the number of Nevadans unnecessarily facing homelessness. And thank you, Assemblywoman Summers Armstrong, for bringing this bill forward.
If you have recently joined the call and would like to testify in support of Assembly Bill 340, please press star 9 now to take your place in the queue.
Good morning, Chairwoman Miller and members of the committee. For the record, my name is Russ James, RUSSJAMES. I'm with the Nevada State AFL-CIO. I'm here in full support of Assembly Bill 340, and I urge the committee to support it as well. Thank you for your time.
Good morning. My name is Linda Ward Smith, and I am here in representing the American Federation of Government Employees, and I am just calling in support of the Assembly Bill 340, and I urge the committee to support it as well. Last name is spelled Ward-Smith. Thank you.
There are no other callers choosing to testify in support at this time.
Thank you so much. With that, we will return back to Carson City for testimony in opposition. Please proceed.
Good morning, Madam Chair and members of the committee. My name is Tiffany Banks, spelled B-A-N-K-S, and I am General Counsel for the Nevada Realtors. We are testifying today in opposition of AB 340. We would like to thank Assemblywoman Summers Armstrong for continuing to work with us on this bill and get us to a place where there is a fair and balanced approach for both landlords and tenants alike. It is our understanding that most states do have an informal eviction process. In the interest of time, I'm only going to touch on a few of the concerns we have had and be as brief as possible. In Section 2, subsection 2B, it is not clear whether it is meant to notify a tenant that failure to act may result in a summary eviction or to rather explain the summary eviction procedure. It is crucial that tenants have a clear understanding of what the notice actually means. The more confusing a notice gets, the harder it is for the tenant to understand what action they have to take, which ultimately defeats the purpose. Chapter 40 is already extremely confusing as drafted, and much of this language is creating more confusing language. Section 2, subsection 3 uses language already required by 40.280, stating that a landlord shall attempt to deliver personally in the presence of witness or without a witness if the constable, sheriff, or process server. If unsuccessful as drafted, this bill eliminates the ability to serve on a person of suitable age and discretion who opens the door, and rather requires the landlord to post and mail using overnight mail, currently not required in statute. Section 2, subsection 6, no method of service is identified. It appears Section 2, subsection 6B1 adds an additional 10 days to the eviction process to an already extremely lengthy process. Finally, Section 2, paragraph 7, it should be required that the tenant raise any legal defense they may have in the answer, as well as any stay of execution of an eviction order, so the answer also includes any defenses to be considered. As you can see, there are some difficult issues that need to be worked out from the legal, technical, and policy perspective, and I just covered a few of these today. We will continue to work with the bill sponsor and legal aid to address these issues. Thank you for your time today.
Thank you, Madam Chair. Members of the committee, I'm thankful for the opportunity to be before you today. For the record, John Sandy, that's Johnsande, here today on behalf of the Nevada State Apartment Association. I'd like to first recognize and thank Assemblywoman Summer Armstrong. I truly valued and enjoyed our conversation regarding this important piece of legislation. However, we are opposed here today on the bill. I don't have time, and I don't think it would be worthwhile to walk through all of the issues as the bill is currently drafted, but instead maybe offer the main reason for our opposition. Our opposition is based on the fact that this will, as drafted, have an impact on the cost and the affordability of housing. Housing in our state is an ecosystem. If we increase costs within the ecosystem, the costs will be spread throughout. In this case, those costs will be incurred by existing and new tenants through higher rents. This body has devoted countless hours seeking policies that can help with housing costs, discussing issues like homelessness, low-income housing, affordable housing, attainable housing, workforce housing. In our opinion, it is imprudent to simultaneously pursue policies that will thwart efforts to reduce costs in housing. With that said, there's a bright side. We believe this bill is an opportunity. The current eviction process in Nevada is convoluted, difficult, and unnecessarily expensive. In fact, over 1/2 of the evictions initiated in the state are initiated by attorneys. If we can create a process that is simple, streamlined, and capable of handling without attorneys, we can actually help landlords and tenants and potentially make a dent in some of the housing issues that we have. Now, we have made a commitment to work with the proponents of this bill in an attempt to accomplish this goal. We are not opposed to reworking the summary eviction process and changing the order or the way that notices are made to tenants. However, we believe this process does need to be streamlined and efficient. And just a little bit of perspective, and it's been discussed a little bit today, but this process is emotional for everybody. Landlords have costs and obligations they need to make, not only to creditors, but to their other residents. They are intimidated by the system as well. Hopefully we can all work together to find a system that makes sense for all Nevadans, and we appreciate the opportunity to be a part of it, and again, want to thank everybody involved.
Thank you, and I appreciate your willingness to continue working with the bill sponsor. Thank you for that.
Good morning, Chair and members of the committee. For the record, Dylan Keith, D-Y-L-A-N-K-E-I-T-H with the Vegas Chamber. We are in opposition to the bill today as written, but we will continue to work with the sponsor. Evictions are not an easy process, and they are often drawn out in length. While we appreciate the sponsor's intent with this legislation, we do not believe that, as written, this bill will alleviate the issues tenants face. Currently, tenants and landlords are often able to find a solution before engaging with courts, as generally neither party actually wants to go through this process. We believe this bill will remove that mediation period between the parties and will draw out the length of time for evictions, increasing the cost on landlords and tenants. We will continue to work with the sponsor, and we thank you for your time.
Thank you for that. Is there anyone else here in Carson City wishing to testify in opposition? Not seeing anyone. Broadcasting, can we go to the phone lines, please?
To testify in opposition to Assembly Bill 340, please press star 9 now to take your place in the queue. Caller with the last 3 digits 583, you are unmuted on our end and may begin.
My name is Ron Ariel, A-R-Y-E-L, yeah, for the record, and I'm in Reno, Nevada. And I am opposed to this Bill 340 because it has nothing to do with alleviating the problems that it says it will. Instead, it's a bill that will make much more difficult for landlords to properly evict tenants. If you want to help tenants, then there are simple things you can do. For example, increase the summary eviction notice time from 7 days to 10 days or 12 days. I certainly would be 100% in favor of increasing access to legal aid, spending more money to subsidize legal aid to provide all tenants with access to an attorney or to a legal aid center. If you want to increase my property taxes modestly to arrange for that, I'll be the first one to fork over a check to the property taxes to help that. I'm fully in support of that. But unfortunately, Jonathan Norman's, frankly, wild exaggerations about what.
Okay, sir, we're not going to comment on. Sir, we're not going to comment on other individuals. Please stick to the policy.
Okay. Well, the proposed policy is based on exaggerations and on statements that are not supported by data. So it's incumbent on the proponents to prove their case and show the data, and they haven't. The last thing I'm going to say is if you remove single-family home zoning restrictions from wide swaths of Nevada and allow the market to operate, you'll get a lot more housing at different price points, and you can even require that some of that housing be restricted to low income or moderate income. That's going to fix your housing process, not putting burdens on landlords and pretending that rent control or making the eviction process more complicated is somehow going to protect tenants. Thank you very much.
Thank you, sir.
Caller with the last 3 digits 600, you are unmuted on our end and may begin.
Good morning, Madam Chairman and members of the committee. My name is Kirk Johnson. I'm an attorney in Reno. The spelling of the name is Kirk Johnsson. I'm really calling to express opposition to the extent this bill applies to commercial evictions. I have handled commercial evictions both on the landlord and the tenant side for close to 30 years here in Reno, and in fact, I think every bit of testimony that has occurred today has been focused on the residential side of the equation, and none of that obviously applies to the commercial side. And I'm particularly concerned with Section 2, subsection 6, which basically requires the landlord to, after they've already served a 5-day notice that the tenant has not responded to, then has to file its landlord affidavit, serve that affidavit, and the tenant now has another 10 days to respond. The way it works on the commercial side is most of these leases have a requirement. Before you can start a summer eviction, the tenant has to be in default. In order to put the tenant in default under the lease, you usually have to give them some sort of written notice. So by the time we get to this third landlord affidavit and serving it, we're now giving the commercial tenant a third opportunity to pay its rent. Again, these tenants are theoretically sophisticated businesses. Most, if not all, are entities. So as entities, they have to be represented by attorneys in the process. There really is no reason to make this cumbersome process and procedure that basically more than doubles the response time for commercial tenants to really even have that applicable to the commercial eviction process. So I would just thank you for your time.
Good morning, everyone. CYRUSHOJJATY. I will ditto the comments made by the previous callers. What is causing this housing unaffordability is a result of largely these eviction moratoriums that we were told that we had to have them because of a so-called pandemic, and yet we have not been told whether these measures have worked. If you look at the state of Nevada, it is 1% only urbanized. 99% of the land is available. We have a lot of space and room to grow. And part of the reason that's causing the housing shortage is because we have a lack of housing and there's a lack of construction. And we have technology such as 3D printers and Boxable that can easily produce tiny casitas very easily. Not to mention, we have tens of thousands of hotel rooms. We can apply a similar model in terms of building housing, which they're doing that in many inner cities like San Francisco, New York, and Chicago, and build them in a lot of those vacant lands, or actually empty parking lots that we have out here. Ta-da! Problem solved. And not to mention, a lot of the code, the permitting costs, that drives up prices. I just want to know, when people say housing is a right, what am I entitled to? A drawer? A mansion? And not to mention, this is one of the reasons why immigration and family policies are very important. Thank you so much, and please reconsider the bill or vote no. Yield my time.
Next caller.
You have recently joined and would like to testify in opposition to Assembly Bill 340, please press star 9 now. There are no other callers choosing to testify in opposition at this time.
Okay, thank you so much. And again, I just wanted to check in on Las Vegas. There's no one there in Las Vegas to oppose the bill? Okay, thank you. With that, then, we will go ahead and open it up for testimony in neutral of Assembly Bill 340.
Good morning, Madam Chair and members of the committee. For the record, I'm Mindy Elliott with Flynn Judici Government Affairs, here this morning in a neutral capacity representing both the Southern Nevada Regional Housing Authority and the Rural Nevada Housing Authority. And with me today is Mr. Brewer, who will also have some comments. We want to know that want you to know that the housing authorities do everything. All three housing authorities do everything possible to keep tenants in housed. However, those that there must be evicted as a last resort. But first, I want to personally thank Assemblywoman Summers Armstrong and Mr. Norman for bringing AB 340 forward. I'd like to thank both of them for their passion and certainly their commitment to this issue. Our late night, and I mean late night discussions, have been very positive. I want to thank Assemblywoman Summers Armstrong for agreeing to remove Section 7.3 Sub 2. We are anxious to continue to support the Assemblywoman and Mr. Norman in this effort and to continue to work with Mr. Norman on a few more small tweaks on behalf of the housing authorities that will not change the substantive intent of the bill. So with that, I want to thank you and again thank Assemblywoman Summers Armstrong for presenting AB 340 this morning. Mr. Brewer.
Good morning, Chair Miller and members of the committee. Thank you for this opportunity today. I'm Bill Brewer, B-R-E-W-E-R. I'm here representing the Nevada Rural Housing Authority and for the purpose of this meeting, also Reno Housing Authority today. We're here in the neutral. We are, as Mindy said, we appreciate Assemblywoman Summers Armstrong working with us and really trying to make this bill functional for all of us. We appreciate the opportunity to have input. We're just here to indicate that we administer federal programs and federal dollars in support of housing. And those programs come with a lot of requirements, most of them far more stringent than anything we'll see in Nevada state law. And so when we find bills that are duplicative and tend to treat us in a different way than any other landlord, it becomes a little more challenging for us. And so our only concern with the bill is just technical in nature, to make us just like any other landlord is all we're looking for, and we're working with the sponsor to get that done. So thank you for your time today.
Thank you so much. Is there anyone else here in Carson City that would like to testify in neutral of Assembly Bill 340? Not seeing anyone. There in Las Vegas, are you, please proceed with your testimony in neutral.
Chair Miller and members of the committee, I appreciate the time to spend with you today. For the record, my name is Maria Moore, M-A-R-I-A-M-O-O-R-E, and I'm the Nevada State Director representing 347,000 ARP Nevadans. In general, we do support AB 340. However, we believe that there's ways to strengthen this legislation and are working with Assemblywoman Summers Armstrong, and I really appreciate her leadership. According to ARP statistic analysis of data available by United States Census Bureau, in the state of Nevada, more than 4,700 older adults age 55 plus are expected to be evicted in 2023, and more than 3,200 older adults 55 plus are expected to experience homelessness. Furthermore, according to the same data, close to 13,500 people for all ages are expected to be evicted in 2023, and more than 9,300 persons for all ages are expected to experience homelessness. We would like to provide two recommendations for AB 340. In relation to Section 2, when landlords provide eviction notice to tenants for non-payment of rent, we may want to require landlords to provide all the rights, remedies, and/or rental assistance programs available at federal, state, or local level available to the tenant to seek help with the payment of rent. Invariably, tenants do not have information about their rights, remedies, or assistance that they can have. Providing such information along with notice will help tenants understand their rights. Furthermore, we would request Nevada Housing Division to work with Nevada Attorney General's office to develop flyers that landlords can provide to tenants with notice of eviction. Secondly, we would like to suggest that the state work on creating eviction diversion programs that will allow landlords and tenants to mediate and settle disputes out of court before any eviction proceedings are instituted. It is proven that partnerships with local court systems, legal system organizations, and critical tools for preventing housing insecurity and helping landlords recover from rental arrearages. Similarly, programs have been introduced in Massachusetts and also local level in Kentucky, Tennessee, and Pennsylvania. Thank you.
Good morning, Assemblywoman Miller and committee members. My name is Barbara Paulson, B-A-R-B-A-R-A-P-A-U-L-S-E-N. I'm a member of Boulder City United Methodist Church, which is a proud member of Nevadans for Common Good, a broad-based community organization representing over 100,000 people in Southern Nevada. Our organization, through small group meetings and numerous neighborhood walks, have interacted with countless numbers of Southern Nevadans on housing issues over the last several years. We've heard countless stories from tenants who don't understand what the posted eviction notice means, don't know how to access the court, have had difficulty navigating the court system when they have tried, and many, for a variety of reasons, avoid the court system and just self-evict. Not only, as we've heard this morning, does this leave many vulnerable people with situations regarding housing, but it also prevents the courts, social services, and housing advocates from having a clear picture of what the eviction levels really are in our community. Since the eviction is initiated by the landlord, the burden of moving that forward in the court system is necessary, and we do very much support the part of the bill that is changing so that it is the landlord who initially has to file with the court. Our concern is in Section 2, subsection 6. Just ahead of that, in subsection 5, there are very clear and specific guidelines given to.
If you have a specific concern with the policy, then that would be more opposition. The last testimony we heard had more suggestions, but if you have an actual conflict with the bill, so do you want me to move your testimony into opposition?
No. I do have a suggestion. I'm just getting to that right now.
Okay, let's hear the suggestion.
Okay, landlords in subsection 5 of section 2 are given clear guidance on what they need to submit to the court when they first file. Subsection 6, also in section 2, tells what the tenant will receive from the court, but does not give them any guidance in how to do that written report. It just says they must file a written response. We already know that lack of people coming to the court is a real issue in making this whole process successful. We feel that there needs to be language in the bill that provides guidance and assistance that will encourage and enable tenants to respond to the court and not to continue to self-evict in the numbers they have. So we support the concept. We would like to see that change in the bill, and therefore we are stating neutral stance.
Thank you. And
Thank you for your time.
You're welcome. What you probably can't see is that the bill sponsor and co-presenter were taking notes as you were making those suggestions, okay?
We appreciate that very much. Thank you for your time.
Thank you. Is there anyone else there in Las Vegas that would like to testify in neutral? Okay. Not seeing anyone, then I will go ahead and close testimony and welcome the bill sponsor and presenter back up for any final remarks.
Thank you, Madam Chair and members of the Judiciary Committee. I know this was a long presentation. There's a lot to digest here and a lot of emotions, and I will try my best to keep mine under control. Whew. During the pandemic, the majority of the calls that I received were from people who were being evicted. They did not know what to do. And by the time a notice was on their door, often it was too late. I was so grateful when the CHAPS money came and we had a process where we could send our constituents to get assistance because people were out of work and they were able to be stabilized and not homeless. We recognize that things are balancing out and the CHAPS program has ended, and there will be other crises. But what we're supposed to do as leaders and people who raise their hands to do this work is to make sure that we are prepared the next time, that we present legislation and we propose legislation and we lobby within our own ranks for legislation that makes life equitable for our constituents. I represent the 6th District in Las Vegas. These are regular folks. They don't have attorneys on speed dial. They don't have lots of money. They voted for a girl with red glasses. And they sent me here to do something about this issue. And I promised that I would try. And I know this is hard. And I know there's a bunch of pushback. But we can't have a process, in my opinion, that is more fair and equitable and clear for multi-million-dollar businesses to fight with one another than it is for regular people to stay housed. That is not the Nevada way. Equity, care, and fairness, that is the Nevada that I know, that I represent, that I love, and that I want to see. And I ask you to please support this. We will continue to work with anyone who will come forward with ideas. But the one thing that is most important is that this is fair. And I thank you for your time, and I thank you for listening. I'm in my mid-50s, so everything I get a little emotional, so please excuse me. But thank you. I really appreciate your time and for you listening. Thank you.
I can't really, Jonathan Norman for the record, I can't follow that. I just want to thank everyone for their time and attention to this important issue, and I want to thank the sponsor and all the commenters, both in support and in opposition. I think got a lot of good notes, and I think we can get somewhere and get to a consensus, so I appreciate your time this morning. Thanks.
And I do want to say, Madam Chair, this is Chandra Summers Armstrong for the record. Thank you to Jonathan Norman and for legal aid. They have served and saved a lot of our constituents, and we should honor them and thank God for them. They do God's work, and I appreciate all that you do. Thanks, Jonathan.
Thank you so much. Yes, thank you, Mr. Norman. It was a tremendous presentation. And Assemblywoman Summers Armstrong, you do not need to apologize for emotion. When people elect us, what they're hoping is that we see them and feel for them as people and humans, first and foremost. And so being passionate about our fellow Nevadans is why we're here. So thank you so much for that. With that, I will go ahead and close the hearing on Assembly Bill 340. Our last item today on the agenda is public comment. So anyone wishing to make public comment, again, this is not to make comments on the bill that we just heard, but on any other issue that's under the purview of this committee. So is there anyone here in Carson City that would like to come forward and make public comment? Not seeing any. Is there anyone in Las Vegas that would like to make public comment? Don't believe anyone's still there. So with that, broadcasting, will you open the lines for public comment, please?
To provide public comment, please press star 9 now to take your place in the queue. There are no callers choosing to provide public comment at this time.
Okay, thank you for that. Well, with that, that ends our business for the day. Thank you, everyone, and I will see you back tomorrow morning at 8 a.m. This meeting is adjourned.